welcome to The Firm. On the show this week,
management lies. Why then should Ranbaxy's shareholders pay the price? And the washout for Nirma in the Supreme Court.
incomplete testing records, an inadequate stability program, significant deviations from good manufacturing practices, selling adulterated drugs, ignoring deficiencies found by external auditors, and knowingly making materially false, fictitious, and fraudulent statements to the US FDA. For doing all of this over 7 years, from 2003 to 2010, Ranbaxy will pay a criminal fine of $350 million and a civil penalty of $150 million. That's $500 million, over a third of which, in a manner of speaking, will be paid for by Ranbaxy's public shareholders. Now, I'm sure you've heard and read enough about Ranbaxy these past few weeks. What a horror. More so because while the company and its shareholders will bear that $500 million burden, erstwhile management will go scot-free. Or can shareholders take action against them? To answer that question, I'm going to first turn to New York, to Adam Emmerich of Wachtell Lipton. Adam, thank you so much for joining me. Always a pleasure to have you on the show. Before I get to my first question, Adam, I want to quote to you what the U.S. Attorney for the District of Maryland said, and that is that Ranbaxy is being held accountable for a pattern of violations. Clearly, this is not a one-off lapse in judgment or one-off set of manufacturing errors. These were persistent violations for a period of almost 8 years. Why then did the U.S. government authorities take action only against the company and choose not to take any action against individuals in management who allowed for these violations to take place for those 8 years?
Well, two answers. First of all, as Willie Sutton, the famous bank robber, is reputed to have said, why did he rob banks? That's where the money is. So Ranbaxy is a major corporation with major operations and a subsidiary in the U.S., and was in a position to agree, as essentially a condition of continuing to operate in the U.S., to a very major financial settlement. I don't know the details of all of the managers and the former promoters, but I would think that in order to track them down and to collect $500 million from them, very much more difficult than doing so with Ranbaxy. The second half, though, I would say is the company's settlement doesn't absolve any individuals who may have been personally responsible for any wrongdoing. If there are individuals who've committed wrongdoing, I certainly would be cautious in advising them that they are off the hook or scot-free simply because the company has entered into a settlement. And in fact, generally speaking, rather the opposite. If the company has admitted wrongdoing which obviously must have been carried out by individuals, it's a very bad thing for those individuals, because not only has the wrongdoing been admitted by someone in a position to know, which is the company itself, but the company then becomes a cooperating agent of the government, generally speaking, even formally as a part of a settlement, to pursue claims against individuals. The company itself may have claims against individuals for indemnification for having personally committed the wrongdoing, which caused the company to be liable to a fine. So the individuals by no means are off the hook simply as a result of the company having agreed to this settlement.
But in the early part of your answer, Adam, you did bring up the issue of jurisdiction. So would the U.S. government authorities have jurisdiction to go after Indian nationals who were management members, let's say during the period of 2003 to 2010, depending on the evidence that they have against those specific individuals? Well,
if an individual, even someone who's outside the U.S., there's different standards of intent and scienter, as we lawyers call it. What mental state you had to have in terms of the knowledge of the consequence of your actions. But to take an extreme case, if you knowingly and willfully and deliberately caused some adulterated substance, a life-threatening substance, to be distributed to customers in the U.S., understanding it was coming to the U.S., understanding it was dangerous, and so forth. So I'm taking an extreme case, some elements of which may be present here, some which maybe not. But certainly if you have done that and tried to hurt people or recklessly been indifferent to hurting people in the U.S., then I think, generally speaking, you would be liable in the U.S., subject to your being got a hold of, right? So if you come to the U.S., then you could be liable to arrest and punishment and so forth. If you are outside the U.S., you first have to be brought to the U.S., either through extradition which varies country by country, whether for criminal matters, civil matters are much harder. So all these things make it difficult to hold people who are legally liable for conduct in the U.S. but who are not themselves in the U.S. responsible for their actions, depending on the practicalities of each particular circumstance.
The next question I want to ask you is whether shareholders can take any action. Now, Ranbaxy is an Indian listed company. It has no listing in the US. It does have a GDR, which is listed in Luxembourg. It has foreign institutional investors. We don't know the full list of them. I don't know if they include any US-based financial institutions that are invested in Ranbaxy. But I'm just curious to know, if it does have any American investors, would there be grounds for those shareholders to bring action against the company as well as its erstwhile management?
You know, it's interesting. It's sort of a form of, beneath the surface, a wish for some kind of legal colonialism in the 21st century. Because, you know, the logical place for someone to sue an Indian company that's principally listed in India for a claim either within the context of the corporate law, saying I'm a shareholder, a corporation has certain duties to shareholders, or a director or a manager has certain duties to shareholders, that would all be the law of the jurisdiction of incorporation. You may have claims brought under the securities laws, under the stock exchange rules, saying there was a misstatement or there was impropriety involved in the listing or the offering of the company's stock. And again, where that listing and offering is not in the U.S. but conducted offshore, the logical place to bring a claim about that would be in that place. And in fact, that's what the law in the U.S. is. There's a famous case here decided by the Supreme Court just a few years ago called Morrison, involving the National Australia Bank, where people in the U.S. sued the bank and said that the bank had done bad things and they'd been defrauded and they'd lost money in their investment. And the Supreme Court said that's very interesting, but if you bought the stock offshore in a foreign company, in a foreign transaction, and it's listed in a foreign place, it really doesn't belong in the U.S. So I would say, you know, this is a case where I would hope, if it's appropriate, Indian justice would rise to the occasion, and whether it's through the corporate law in India or whether it's through the stock exchange rules or the regulators, if something has been done that's unfair and improper towards investors, India is a logical place for that to be rectified.
All right, Adam, thanks very much. India is the logical place for that to be rectified. Amit Desai, Anand Desai, do we have grounds in India for Indian shareholders of Ranbaxy to bring any action against the erstwhile management, or let me say those who were managing Ranbaxy between the years 2003 and 2010?
Menka, I think we are far away from the way this jurisprudence has developed in the Western world. And whilst in the recent past we find some efforts being made by the capital market regulator, and for that matter by new legislation, to try and bring in this concept of class action suits to protect investors, under the general law in India, I think we're still far away from being able to actually achieve what the US has been able to achieve in relation to class action suits. So it's going to be extremely difficult, I think, in the context of the Indian jurisprudence as it stands today, for the shareholders of Ranbaxy, promoter or non-promoters would stand on a slightly different footing, because
I'm talking public shareholders,
but the public shareholders to really actually be able to maintain some kind of a class action or a derivative action in India. That's the sense that I have today.
Anand, but there is scope, right? Company law provides, I think, under sections 397, 398, cases of oppression and mismanagement. Not saying this, fits that, but there is that. There is scope for derivative action in this country as well under the corporate law. So I'm just curious to know, is there any way that public shareholders of Ranbaxy can bring action? And I know it's complex because they're not bringing action against the current management. They're bringing action against the management of 2003 to 2010.
So you're right. We do have oppression mismanagement sections in the Companies Act that requires a threshold of 10% of the shareholders or 100 shareholders to bring the action.
Right.
Typically, as you said, that's for current mismanagement or current oppression.
You can't do it against management that existed when the violations took place.
No, I think what you're looking for basically is the company should be made whole by the past management for its acts. So the company today files an action against past management.
Okay.
For example, for
so Ranbaxy would have to do that then.
That's one option.
Okay.
If they can demonstrate that the past management created a situation which caused losses to the company, that's one possibility. But the second option would be for shareholders today to ask the company to take such action. Amit referred to the derivative action concept. So a company can also be sued along with the wrongdoer by a shareholder. And the shareholder can say that I cannot get the company to sue for whatever reason, but I am losing because the company is losing. So let an order be passed against the wrongdoer in favor of the company or in my favor. The problem with that is that the defendant will say a whole bunch of things, that who are you, how are you affected, etc., etc. Because shareholders are a moving target, especially today in a listed company. So were you holding shares at that time? Are you holding shares today? When did you buy them? What price did you buy them at? Were they already discounted, taking this into account?
So that's a curious situation, right? Because if you were holding shares then, every time there was news of an FTA investigation, there obviously would be a reaction in the stock price. But it's only shareholders today who are bearing the brunt of a $500 million penalty, outside of the loss of image and what the impact this will have on future revenue, etc., etc. Hence, today's shareholders have grounds for action?
I think, Menka, let's make it very clear here. I think what we are discussing is really a theoretical issue here, because none of us know what the facts really are, and we are using Ranbaxy as an example or illustration to see whether under the Indian law some action can be taken in the event there is some kind of serious wrongdoing by a management.
Right.
But therefore, coming back to a situation, so let me come back.
If I may submit,
No, but let me,
they've pled guilty to making fraudulent statements.
Let me put it this way, Menka. Let me put it this way. If there was actual wrongdoing, and I'll come back to this issue about pleading guilty in a minute, but if there was actual wrongdoing which was of an extremely serious nature, and the company has suffered significant losses as a result of the wrongdoings of the management, in a given case it may be possible for a derivative action or for the company to take steps against the management to recoup and make the company
before ever?
I'm not aware of.
Companies have sued past management for recovery of damages.
They have.
Of course they have. Liquidators have as well. Not in this kind of situation necessarily.
Yeah. Okay. But let's take this very example from what information that you have here in the public domain, and let's I'm just testing this a little bit. A shareholder comes in and says that I want to take derivative action, the company should take action against the management. The first question that might arise is that this is a settlement agreement. All right. Okay. Now, if it's a settlement, you have one is a civil settlement, one is the criminal settlement. So none of this has actually gone to trial and adjudicated upon.
No, I suppose
now what happens typically
might have to be validated in court.
No, that's true. But that's a standard process.
Yeah.
But the question that might arise, and for example, in all these settlement agreements, typically they're all without admission of liability. Now, and therefore the question
but there is admission of guilt.
Sorry, no, I'm coming to the admission of guilt. So one is the admission of liability. So let's take this as the 500 million, as I said, is broken up into two components. One is the civil and one is the criminal. At least in relation to the civil, they say there's no admission of liability, but for the purposes of avoiding uncertainty, protracted litigation, etc., we are ready to close out this issue and pay the fine. The question is that that's a decision that was taken by current management, not by the past management. The second is, let's take the case of plea of guilty. Even in the case of plea of guilty, we don't have all the contours of what that agreement was. Now, if it was some form of a plea bargain, it sometimes does happen that these pleas also caveat to say that we are pleading guilty, but we are not necessarily we are doing so because we don't want any uncertainty or protracted litigation, because the defense of the previous management may not have been tested in court. So today a current management is going into the system and pleading guilty in relation to actions which are supposed to have taken place by the past management. Now, how do you then say that today that the past management, which may have a legitimate defense to everything that may have happened, which has not been tested, because you have current management on behalf of the company going and pleading guilty?
So what you're telling me very simple terms
so when you have a derivative action,
theoretically there may be grounds for action, but practically speaking it would be very difficult to succeed in bringing this action against the erstwhile management of Ranbaxy.
I mean, to give a small example, the whistleblower in this who filed a civil complaint made very serious allegations, but if you look at the settlement agreement, a lot of those allegations have been sort of dealt with and said that they are not accepted.
Anand, let me put it to you this way, since Mr. Desai is discouraging me from thinking on the lines that shareholders can take action. They've pled guilty to 7 felony counts, right? The DOJ is very clear that there have been fraudulent, fictitious and false statements made knowingly, material statements these. The DOJ has also pointed out in an information docket that there were previous external audits commissioned by the Ranbaxy management of the time which pointed to manufacturing deficiencies which were not necessarily addressed in the manner that they should have been by that management. All of this was not disclosed by Ranbaxy at that time. Corporate law may not give me enough grounds, but under securities law, is there any ground to say that you knew things about this company, you didn't tell me. You eventually exited as a promoter in a few years thereafter, right? You knew the full scope of these investigations. I didn't know it as a public shareholder. I have been, sort of put to some loss. You're using the word, I'm not. I've been put to some loss because of that. Is there grounds there at all for action?
So the law requires, securities law requires disclosure of material events. In this case, if an audit is done, if there's a material finding, and if there's a non-disclosure consequent to that to the stock exchanges or the SEBI, which is the regulator, it's for SEBI then to take action.
I was going to stretch it a little further and say that the earlier promoter group exited while knowing the full scope of these regulations. I'll say the horrid words of insider trading here. It's a question.
It's a question, you're right.
It's a question. You knew more than we knew.
Sure.
You sold out. Now, you could argue that we got an open offer, you had a chance to sell out as well if you wanted to, but we didn't know.
We didn't have the facts.
We didn't have the full information. If there was more information to be had, which seems to be the indication from what we know right now after the Department of Justice put out its press release.
So you have a situation where a very reputed group, well known around the world, comes in and acquires shares in Ranbaxy. One is entitled as a public shareholder to believe that they've done an adequate due diligence and paid a huge
Fortunately,
sum of money.
insider trading rules don't allow them to do any due diligence beyond what is publicly available.
Yeah, so
maybe if the public information was restricted and we only knew that much, they would also only know that much. That's their cause to fight. They may fight it, they've threatened that. But
Yeah, I don't know whether it would sort of give cause for insider trading, and I think that's a fact-oriented issue.
So what both of you gentlemen are very nicely telling me is, Menka, these things happen. Companies mess up over a period of 7-8 years, and shareholders bear the brunt of it. Management doesn't. Management goes scot-free. Directors go scot-free.
So the question that really arises for these kind of actions is a materiality test. Because ultimately, across the world, in every organization, there is always a scope for in the course of discharging your duties, even if you attempt to do them lawfully, you might commit a violation of some law. It happens all the time. Now, every time there's a violation of law and there is a fine or a penalty that is imposed, does that give rise to a class action suit? It can't be, because otherwise no organization will be in a position, no director, no management will be in a position to actually discharge its duties.
I get the principle of what you're saying. I am not trying to bring to book every management for every mistake or bad decision they may have
made. So there's a need for a materiality test.
But this is a unique case.
It is.
Well, let's break it up. I think you have an acquirer who's bought a significant share with contracts.
Yeah.
That's one part. We have a regulator that has a right to investigate and take matters further. Yes, we also in theory have a right for shareholders to take action. It's a question of balancing for the shareholder or shareholders. Suppose the shareholder has got 5%, 8%, 10%. It's a significant shareholding. He decides, no, I want to test this. Okay. Maybe he will. I didn't say it can't be done. I'm saying it's an uphill task, and given the limited information we have, it's even more difficult to opine whether he should do it, should start it.
All right, gentlemen, on that note, and might I say a hopeless note, thank you very much for joining us with your views. With that, let's take a quick break on the farm. Up next,
the washout for Nirma in the Supreme Court.